Thank you for joining our training session. My name is Chris Cheney. I am a regional coordinator for Afghan Legal Services with the International Rescue Committee and a member of the American Immigration Lawyers Association's Afghan Response Task Force. This presentation was developed as a companion to another training, which includes a very comprehensive introduction to temporary protected status, or TPS. In this presentation, we are focusing on TPS for Afghanistan, and we'll start with a review of the designation notice as it was published in the Federal Register, which includes the requirements specific to Afghans and the various basi for designation. Then we'll turn to some big picture analysis, and keeping in mind that TPS can be used for different purposes, we'll focus in on the issue of work authorization, and we'll consider when TPS is a good strategy as a means of avoiding a gap in work authorization. Then we'll jump over some hurdles and dive into the weeds that are common to Afghan TPS, including a review of the 3 new exemptions to the terrorism-related inadmissibility grounds, or TRIG, that were issued in June 2022. And how these questions are very relevant to Afghan TPS. And we'll also turn to how these questions play out on the form I-821 and the type of information that you should be providing when answering yes to those types of eligibility questions. On May 20th, 2022, DHS Secretary Alejandro Mayorkas published the designation of Afghanistan for TPS in the Federal Register. The TPS registration period for Afghanistan started on May 20, 2022, and runs through November 20, 2023. Applicants must have continuously resided in the U.S. since March 15, 2022, which means that individuals who entered after that date generally would not be eligible to apply for TPS at this time. Applicants must also show continuous physical presence inside the U.S. From May 20, 2022 in order to be eligible. The majority of the notice is dedicated to answering why was Afghanistan designated for TPS. Let's review what it says. The Federal Register notice provides an historical overview of the security situation, noting that the Taliban controlled most of Afghanistan from 1996 to 2001, invoking Sharia law to remove women from public life, to enforce strict moral codes, and to extract draconian punishments such as dismemberment and public executions. The Register goes on to say that following 9/11, U.S. forces began airstrikes and a ground invasion that drove the Taliban from most of Afghanistan by November of 2001. But then the Taliban began to expand its presence along large parts of the country, and by 2017, the Islamic State in Iraq and the Lebanese Khorasan province, ISIS-K, emerged, which added a new dangerous dimension to the country's security situation. Before the withdrawal of U.S. NATO troops, the armed conflict had taken a high toll on Afghan civilians. According to the UN, more than 116,000 civilian deaths and injuries occurred due to the armed conflict from 2009 until June of 2021, with record numbers of girls and women killed and injured, as well as record numbers of overall child casualties. The Federal Register notice also provides a detailed description of the current humanitarian situation as of May 2022. After waging a 20-year insurgency in August 2021, the Taliban took over Kabul. Today, armed conflict and insurgency continue throughout the country of Afghanistan. According to the DHS, the Taliban is seen as both ill-equipped and unwilling to meet the country's numerous challenges, including the current security situation, economic collapse, a crumbling healthcare system, severe food insecurity, and respect for human rights. Afghanistan is undergoing a humanitarian disaster. The UN has called the current situation, quote, unparalleled, with more than 24.4 million people requiring humanitarian assistance to survive. Half the population is facing acute hunger, including 9 million people in emergency food insecurity, the highest number globally, with malnutrition on the rise, and livelihoods that have been destroyed. According to the DHS in the Federal Register notice, it also says that Taliban fighters are taking retaliatory action against people associated with the Ashraf Ghani administration. Additionally, despite their pledge not to do so, reports indicate that the Taliban are also targeting former Afghan police and military personnel. Rising internal displacement emanates from the ongoing armed conflict and the unstable security. And today, the Taliban is engaged in targeted displacement policies by forcing thousands of Hazaras and former government officials from their homes and redistributing their property to Taliban supporters. DHS goes on to report that the healthcare system is also in a critical state. In September 2021, the World Health Organization asserted that the healthcare system was on the brink of collapse. Taliban restrictions requiring that women be escorted to health appointments by male family members and bans on male healthcare professionals treating women are further compromising women's access to healthcare. Again, this is from the May 2022 Federal Register notice. In that notice, DHS goes on to report that violence targeting women and girls remained pervasive in Afghanistan before the Taliban takeover. And according to the U.S. Congress, the status of women and girls has become, quote, increasingly precarious. Local activists report the occurrence of forced marriages, stating that women are being married as sexual slaves to Taliban fighters. The Taliban have banned girls from attending secondary school past the 6th grade, and rules segregating teachers and classes according to gender has exacerbated a severe teacher shortage and threatens to eliminate higher education opportunities for girls. The Federal Register notice also discusses, and again noting that this is from May of 2022, that Afghan women are unable to hold positions of authority in almost all spheres of public life. They have been barred from paid employment, except as teachers for girls and healthcare workers. In the legal field, female lawyers and judges have left the courts under Taliban pressure and live in a state of perpetual fear that they or their loved ones could be tracked down and killed. The notice also reviews the targeted killings and evictions of Hazaras. An ethnic Shia minority, Hazaras were particular targets of harm by the Taliban during their period of rule in 1996 to 2001. Recently, Taliban fighters massacred 9 ethnic Hazara men after taking control of Ghazni province in July 2021. Hazaras are also enduring a pattern of increasing sectarian attacks from ISIS-K, which over the last several years has been blamed for dozens of bombings and gun attacks on mosques, shrines, schools, as the group views Shiites as apostates. Human Rights Watch and other sources have reported that the Taliban has begun forcibly evicting Hazaras from their homes. In the Federal Register notice, it continues to review restrictions and risks in cases of nonconformity. DHS notes that any optimism that the current Taliban may be more moderate than the Taliban was from 1996 to 2001. Such optimism has faded, as they are reportedly targeting journalists, artists, and musicians, barbers, and those working in fashion, civil society participants, and protesters. The Taliban have announced that they will once again carry out executions and amputations of hands for criminal offenses, and have begun doing so. DHS also reviews challenges for individuals with disabilities. Afghanistan has one of the largest per capita populations of individuals with disabilities in the world. After the Taliban takeover in 2021, any strides that Afghanistan had made in protecting the rights of the disabled through the signing and ratifying of conventions under the previous administrations of Hamid Karzai and Ashraf Ghani have been virtually abandoned. The European Asylum Support Office confirms the stigmatization of individuals with physical and mental disabilities. The Federal Register notice also reviews terrorist groups, although the Taliban pledged not to allow al-Qaeda to threaten the security of the United States and its allies from Afghan soil. Veteran Taliban leaders with deep relationships with al-Qaeda organizers have returned to positions of power, raising concern that the Taliban will once again create a safe space for global jihadists. The Department of State designated ISIS-K as a foreign terrorist organization in January 2016. Now, the threat of ISIS-K is growing with increasing risk to civilians. ISIS-K claimed responsibility for the August 26, 2021 suicide attack outside the Kabul airport and has been behind some of the deadliest operations against Afghan civilians. A feature of ISIS-K's attacks is large-scale suicide bombings of Hazara Shia mosques and gatherings. United Nations Special Representative for Afghanistan, Deborah Lyons, indicated that the Taliban have been unable to stem the expansion of ISIS-K, and that it now appears to be present in nearly all provinces. As of November 2021, she states that the number of attacks attributed to ISIS-K has increased significantly from 60 the previous year to 334. The Armed Conflict Location and Event Data Project, ACLED, which is a nonprofit data collection, analysis, and crisis mapping project. They report multiple recent attacks by ISIS-K during the month of October and November 2021, including engagements with the Taliban and targeting of civilians. Human Rights Watch stated that ISIS-K has repeatedly carried out devastating attacks that appeared designed to spread terror and inflict maximum suffering, particularly on Afghanistan's Hazara community. Reuters reports that with more than 400 Shiite mosques in Kabul alone, total security is impossible and no one knows where the next attack will come. The Federal Register Notice also provides a detailed description of additional issues, including the destruction of infrastructure, danger from landmines, rising internal displacement, and access to food and potable water. Next, we'll turn to a threshold question. Is TPS the right strategy for my client? In the Afghan context, it's important to note that the majority of Afghan arrivals, even though they hold parole status, are, for all intents and purposes, resettled refugees. Historically, the trend has been, when bringing a mass of refugees into the U.S. under parole status, to subsequently enact legislation, which serves as a basic legal step in the overall resettlement process. Here, unfortunately, AAA hasn't passed yet, and the potential for resettled refugees losing their work authorization is looming in the foreseeable future. So next, let's turn to the question of how TPS can be used to avoid a gap in work authorization. First, let's look at those who are using Asylum as their path toward legal resettlement. Unlike I-485 adjustment applicants, which we'll get to later, Asylum applicants are not immediately granted the option to apply for an EAD. Which of course stands for the Employment Authorization Document. There are many different categories of EAD, and essentially they're tied to whatever immigration status you currently have. So for example, the EAD code C8 is used for asylum applicants, and for asylees, which is what we call those who already have been granted asylum, for asylees, the code is A5. Different EAD categories have different procedures, and even within a single category, there might be different subcategories of procedures. The pending asylum EAD, C8, is a great example of how procedures can vary within the same category. We currently have what is known as the Rosario class action, which requires USCIS to adjudicate all initial EAD applications from asylum applicants within 30 days. Keep in mind, this is for your first asylum EAD, not your first EAD ever. So an Afghan parolee who already has a parolee EAD can still benefit from the Rosario class action rules when applying for their first C8 EAD. Pending asylum applicants are not immediately authorized to apply for an EAD. they must wait at least 150 days from the submission of the I-589 asylum application. And then at that point, they can submit their I-765 EAD application. And USCIS will be mandated to adjudicate the application within 30 days. But we've all heard that line before, right? Especially if you're familiar with Afghan affirmative asylum procedures, in which the USCIS is mandated to issue a decision within 150 days. These days, it seems like the norm is for USCIS to miss that deadline. And the same holds true for the USCIS's 30-day deadline under the Rosario class action. Now, there is an inquiry procedure that can be used if USCIS does not meet the 30-day deadline. And recent anecdotes from attorneys suggest that the C8 EADs are arriving within about 60 days if the proper inquiry procedures are followed. So, in a nutshell, the amount of time it takes for an asylum applicant to receive a C8 EAD in the very, very best of circumstances is 7 months, which includes the 5 months of mandatory waiting and the 2 months of processing. But understanding that not everyone submits their I-765 on day 151. Sometimes it takes some prep time to get those out the door. And B, it will take the persistence of a very dedicated and talented attorney to convince USCIS to process that card within 2 months. And even with that kind of effort, it could possibly still take longer. So, if the asylum application is submitted with 6 months left until the parole status expires, this will result in a 1-month gap in work authorization. Now, let's not forget, losing work authorization is a travesty for those currently employed or those seeking employment, not to mention their employers and their family. So this would be very, very bad. Plus, banking on just 2 months for prep and processing is probably not a very good strategy because many cases will take longer, no matter how hard you try. So let's be a bit more conservative and let's bump up the total timeline for C8 EAD processing to 9 months, which includes 5 months of mandatory waiting and then 4 months for prep and processing. Keep in mind, however, that 4 months for an EAD processing time is not really being conservative. I mean, that's still quite optimistic. So with that said, in this scenario, even if the applicant were to submit the application with 8 months left on parole status, they'd still face a 1-month gap in work authorization. So this is where TPS can be a useful way to avoid a gap in work authorization. If an Afghan parolee on the asylum track is 9 months or less from parole expiration, then there is a very real possibility of there being a gap of time between the expiration of the parole EAD and the issuance of the C8 pending asylum EAD. The TPS EAD, which is coded A12, the TPS EAD will cover this gap and it could save the applicant from losing employment. In the SIV context, TPS plays a similar role. Once an SIV applicant receives an approval of the first step of the procedure called the Chief of Mission or the COM request, they will become eligible to apply for I-485 adjustment of status if they're inside the US. There's also an EAD for a pending I-485 applicant, coded as C9. And unlike asylum applicants, adjustment applicants can apply for their C9 EADs immediately. And they can include their forms I-765 together with their I-485s as part of their adjustment application packages. The problem here, however, is there is no such Rosario class action for the C9 EAD category, and processing times can be difficult to predict. If we assume a 4-month processing time, which is also somewhat optimistic, then the SIV applicant would be facing a gap in work authorization if the I-485 were submitted with 3 months left of parole status. Again, TPS can be used to cure this gap in work authorization. But it's important to note that processing times can be difficult to predict, and you run the risk of losing employment if you leave it too late. Of course, the other big question mark is how long will it take to get the TPS EAD? Unlike pending asylum EAD applications or pending I-485 EAD applications, Afghan TPS has seen a tendency in requests for evidence, or RFEs, which could add months to the overall processing time of the application. So that's also important to keep in mind. So where should we draw the line when it comes to using TPS to protect Afghan parolees from gaps in work authorization? When should TPS be used, and when is it not necessary? Like everything else in the resettlement world, it really does come down to timing. If an Afghan parolee has yet to start any application and there's more than 9 months left on their parole status, and they're considering asylum as their path toward legal resettlement, well then, by all means, they should try to submit that asylum application with more than 9 months left until parole expiration. Once you hit the 9-month mark, if you haven't submitted your asylum application, or if you haven't started your COM request for SIV, well then there's a very real likelihood that you'll have a gap in your work authorization if you don't apply for TPS. So at 9 months, you might as well go ahead and apply for TPS as soon as possible if there's nothing else pending. Now, how about those who have already submitted their asylum application? They're on track to get their C8 EAD, not to mention their green cards eventually. So oftentimes, TPS is not really necessary for asylum applicants. Keep in mind also that having a pending asylum application qualifies one for late initial TPS registration, as discussed in the previous training. So it's not like you're missing the boat. All that said, however, C8 EADs can take upwards of 9 months or longer, and if the applicant submitted the I-589 asylum application with less than 9 months until parole expiration, then it might be time to do some quick mathematics, because in this scenario, TPS possibly could be used to prevent a gap in work authorization. And this will greatly depend on the current processing time of the TPS A12 EADs. Turning to SIV, if the applicant has a pending Chief of Mission request, then it's probably best at this point to apply for TPS now. The adjudication time of COM requests are also difficult to predict. This presentation was developed toward the end of January 2023, when COMs are reported to take about 108 days once documentarily qualified. Which is certainly faster than they used to be. But that said, I-485 EADs can take more than 6 months sometimes. And the majority of TPS eligible applicants arrived between around September and November of 2021, so which is less than 9 months away from now. So in other words, if your COM is still pending, then you do face a risk in losing work authorization if you don't apply for TPS now. For those SIV applicants with COM approvals, generally this is another category where TPS might not be necessary because you'll already be eligible to apply for an I-485 EAD, not to mention your green card is imminent. But again, here it depends on when the I-485 was submitted and how much time was left at that point until parole expiration, and the current processing times of the various applications. Next, let's pivot to some common hurdles that are frequently encountered in Afghan TPS cases. And in fact, they're so common that they resulted in some official exemptions. In June of 2022, DHS and DOS collaborated to issue 3 new exemptions to the TRIG. Which indeed is very fortunate given how broadly these bars have been interpreted by the agency. because had it not been for these new exemptions, then a large number of Afghan arrivals would have qualified for not much more than possibly CAT protection under the Convention Against Torture. This first exemption includes individuals who provided limited or certain insignificant material support to a designated terrorist organization. Of course, keeping in mind that Congress has designated the Taliban as a Tier 1 terrorist organization. Examples of what type of support would be covered by this exemption include if one acts in response to a reasonably perceived threat of physical or economic harm, restraint, or serious harassment. It also covers support which is considered minimal and inconsequential, such as paying a small amount of money to pass through a Taliban checkpoint while fleeing Afghanistan. It also covers activities such as paying the Taliban for utilities, or paying a fee to obtain a passport or other type of identity document considered necessary to flee Afghanistan. Keep in mind, however, that this first exemption does not include individuals who share the ideology of the Taliban or who intended to support the Taliban through their activities. The next exemption covers individuals employed as civil servants in Afghanistan at any time from September 1996 to December 2001, or at any time after August 15, 2021. That said, the exemption does not include individuals who held high-level positions or those individuals whose civil service was motivated by an allegiance to the Taliban. The third exemption covers certain Afghans who supported U.S. military interests by fighting or supporting those who fought in the resistance movement against the Taliban, as well as those who took part in the conflict against the Soviet occupation of Afghanistan. The exemption does not include those who targeted non-combatants or U.S. interests, or those who committed certain types of human rights violations or abuses, or acted on behalf of a designated terrorist organization. Turning to the TPS application, Form I-821, we can see the eligibility questions that USCIS uses to gather this TRIG-related information. When answering yes to these questions, an applicant is expected to provide all relevant information so that USCIS can make a determination as to whether an applicant's previous activity is covered by one of the exemptions. If an applicant were to answer yes to a question and not provide all the relevant information, well then USCIS will issue a request for evidence, an RFE, with a detailed list of information that it considers relevant for the question at hand. And this causes delays. We can use recently issued RFEs from USCIS to Afghan TPS applicants to provide us with a roadmap as to what information should be included. For example, here we see the list of information that should be included when answering affirmatively to whether the applicant has served in a military, paramilitary, police unit, or the like. Question 31B asks whether the applicant has served at a location that involved detaining persons. This is another common situation for those who worked alongside US and NATO forces in Afghanistan. And if we turn to the list of RFE questions for 31B, we see that they're different from the 31A list, but they're certainly geared toward whether the activity would be covered in that third TRIG exemption that we just reviewed. Question 32 regarding the use of weapons, or merely being the member of a group in which other individuals used weapons. This is also a common yes question for those who served alongside the US and NATO forces. And in the RFE list, we see some specific questions, such as the type of weapon used, and also an explanation of how these weapons were used. Question 33 asks about the transportation of weapons, also a common occurrence. And question 34 asks about whether the applicant has received any type of military, paramilitary, or weapons training. Many of these questions are eliciting basic data, such as rank, squadron number, or as we see here in number 34, it asks about the type of weapon and the location of the training, whereas some of the other information listed is kind of digging a little deeper, such as here, and we see in number 34, it asks for an explanation as to whether the applicant ever used a weapon against another person. Or back in question 31A, it asks whether the applicant participated in any combat, and if yes, to provide a full explanation. This is a good place to remind the applicant that even though there won't be a USCIS interview as part of the TPS procedure, there's a strong possibility that the applicant will appear at an asylum interview or an adjustment interview at some point in the future. And there's a very good chance that the adjudicating officer of that future application will have a record of this current TPS application. So the information discussed in these questions and the corresponding answers could certainly be raised again at a future date. Frequently asked questions. Is polygamy waivable? No, polygamy is not waivable, nor are there any exceptions or exemptions to the polygamy bar. But it should be said that the question of eligibility here asks, quote, do you now practice polygamy? So if the applicant previously had polygamous relationships, it's okay as long as those are over with now. Is living at a lily pad considered firm resettlement? Firmly resettled in another country before arriving to the US could make one ineligible for TPS. There are some exceptions to this rule, and these exceptions cover the typical situations that many Afghans find themselves in. For example, the majority of Afghan arrivals initially processed through the overseas lily pads before being transported into the US. There is an exception we see at 8 CFR 208.15, which says that the firm resettlement bar does not apply if entry into the third country was a necessary consequence of their flight from persecution, and they remained in the lily pad country only as long as was necessary to arrange onward travel, and they did not establish significant ties in that country. Is lily pad and safe haven the same thing? Here's a good question which comes from the Kurzban staff, and this is very important. In the context of Operation Allies Welcome, there is a distinct difference between lily pads and safe havens. In a nutshell, lily pads are located outside of the US, and safe havens are located within the US. These terms should not be used interchangeably. When USCIS says that I-485s can be submitted from a safe haven, they don't mean to say that they can be submitted from outside the US, because safe havens can only be located within the US. What if the applicant was arrested in another country and doesn't have the documents? If the applicant has ever been arrested, charged, or convicted for a criminal offense, you'll need to provide a certified copy of all arrest reports, court dispositions, sentencing documents, and any other relevant documents. This includes situations that occurred either inside or outside the US. If official documents are not available, USCIS asks first for primary evidence, such as a certificate from the custodian of the records explaining that the records cannot be disclosed, or for secondary evidence, such as photocopies from previous records. And if neither primary or secondary evidence is available, then the applicant must provide a written statement affirming the relevant information. Similarly, if documents such as identity and nationality documents are not available to the applicant, you may provide an affirming affidavit showing proof of unsuccessful efforts to obtain such documents, and why the consular process to obtain such documents is unavailable to the applicant. Details about how USCIS treats missing documents can be found in the Form I-821 instructions, which is found on the USCIS Forms page. What if the applicant came as an Afghan parolee after March 15, 2022? Unfortunately, this is a question relevant to thousands of Afghan parolees who arrived after the designation date. Essentially, this means that they are not currently eligible to apply for TPS, and they don't have the option of using this work authorization gap guardrail, at least not for now. Keep in mind that redesignation of TPS is certainly very possible, and this is when the executive branch essentially starts a new TPS for Afghanistan, with the required dates for residence and continual physical presence being reset. So this is different from re-registration, which is when TPS is extended for an additional period for those who already have TPS. So in order for Afghan parolees who arrived after March 15, 2022 to be eligible for TPS, there must be a redesignation of TPS for Afghanistan. Typically, these occur about 60 days prior to the expiration date of the current TPS period, and the same time that re-registration decisions are made. And it should be noted that redesignation is not unusual. For example, it just happened a couple of months ago for Haiti. So there is much optimism that redesignation for Afghanistan will happen as well, and hopefully the administration will do it early. It's not necessary to wait until there's only 60 days left. If an Afghan parolee's asylum application were to be denied, how would TPS affect future options? And would it have any effect on the, quote, second bite of the apple? Theoretically, this is a tricky question, but practically speaking, maybe not so much for Afghan parolees. Keep in mind that generally it's better to have TPS than not to have TPS for various reasons, including work authorization and protection from deportation. And it should be noted that TPS and asylum are common bedfellows. For example, holding TPS is an exception to the one-year filing deadline of asylum, and having a pending I-589 asylum application qualifies one to submit an initial TPS application after the deadline of the registration period, otherwise known as late initial TPS. When it comes to affirmative asylum applications that are denied by USCIS, having TPS or not having TPS does have a very real effect on future options, because if an applicant has TPS when the I-589 is denied, then USCIS will not refer it to Immigration Court for removal proceedings. But that's a good thing, right? Well, not always. One advantage of being in removal proceedings is the, quote, second bite of the apple, because the applicant will be able to submit a brand new asylum application with the immigration judge as a defense to removal. And in some situations, this is an advantage because it allows the applicant to basically try and convince a different adjudicator that they are in fact eligible for asylum. It's like getting a new pair of eyes on the case, and essentially it's useful for when the USCIS Asylum Office erroneously denies the I-589 application. If an applicant has TPS when USCIS denies the I-589 application, the case will not be referred to the Department of Justice, and the applicant won't have the option of getting an approval out of an immigration judge. Now, it's important to keep in mind a couple of factors when asking this particular question in the Afghan context. First, if USCIS denies an I-589 for a TPS holder, then USCIS retains jurisdiction and the applicant can submit another I-589 with the Asylum Office. There's a higher burden here, of course, compared to the initial application, and the applicant would need to overcome whatever problem there might have been with the first application. So, for example, perhaps the applicant applied pro se and made some mistakes, or perhaps the applicant can show a change in country conditions. And this is certainly applicable in the Afghan context, as unfortunately, we have seen that the conditions there are getting worse on a daily basis and have certainly gotten worse since TPS was designated last year. But here's the thing. Another factor that plays a big role in this discussion is the 99% approval rating of Afghan asylum applications. Sure, only a small percentage have been adjudicated, but for what it's worth, that number hasn't dipped below 99% ever since USCIS started bragging about their Afghan asylum approval ratings back when they only had about 20 or so I-589 approvals in the book. If they deny an Afghan case, it'll probably not be based on a mistake by the adjudicating officer, and it would likely face similar difficulty with an immigration judge. So, with all of this in mind, perhaps asylum applicants from other countries that have a less than, say, 30% approval rating might think twice about TPS. But in the grand scheme of things, for Afghan parolees, the risk of a gap in work authorization far outweighs the risk in a mistaken denial from the USCIS Asylum Office, particularly in light of the ability to apply affirmatively a second time. Why is it important for applicants to keep records of their TPS applications? TPS is not the final destination for Afghan parolees. It is merely a tool that is being used on their way to permanent residency and U.S. citizenship. As they go through these future immigration processes, it is important that they have complete records of their TPS applications because they will be encountering these same issues in their future forms and in future interviews. As legal service providers, we can't move forward with residency or naturalization applications without a thorough review of the applicant's immigration history, and having to seek out these records through FOIA requests or otherwise can cause serious delays. So make sure you explain this concept of the future self to your clients as you're assisting them with their TPS applications. When considering TPS as a strategy for avoiding gaps in work authorization, why should we be conservative when calculating processing times? Think of it this way. The best guardrails for roadside safety are the ones that have already been erected when the truck is bearing down on the roadside cliff. We need to make sure that Afghan parolees receive their next EAD well in advance of their parole expiration dates. So let's get those guardrails up and keep on trucking.